Hello everyone, good evening. Hello, good evening. Am I audible? Hello Krishna. Hello Fatima. Who else is here? Great. So yesterday I think we discussed or we finished at various aspects of basic structure, correlation between fundamental rights and DPSPs, right? Any doubts with respect to yesterday's lecture? Who else is here? Amrutesh, Fatma, Krishna. Okay. So let's discuss about the various types of risk, majority or types of majority used under the Constitution of India, right? Are you aware about the different types of majority used under the Constitution of India? Fatima, Krishna, Amrutesh? Okay. See, simple majority. So these different types of majorities, please understand this concept first. There are different types of majorities, and these different types of majorities are used for different purposes. Types of majority are used for different purposes. Okay, they are used for different purposes. As I've told you, the purpose is to amend the Constitution. So these purposes are basically to make changes, either to make changes in the Constitution, that is amendment, or different provisions are provided in the Constitution for different other purposes. So other purposes such as other purposes includes passing of bill, right? Other purposes includes removal of important constitution office holders, such as removal of president, removal of judges, removal of chief election commissioner, right? Other purposes to pass special type of bills or special type of laws. Fourth, to pass different emergency provisions or to proclaim emergency under Article 352, 356, 360. So these are the different types or the purposes for which emergency is used. Okay, and for these purposes, or let's say fourth, fifth, making changes in the name or boundary of states, making changes in the name or boundary of states. So these are the various purposes highlighted in the Constitution for which we require different types of majority. So on this note, let's go through. Sixth would be formation of government. Sixth would be formation of government. I am sure you have heard that in Parliament, the majority party needs 272 seats to win the election, right? 272 or more, that is called the magic number. But how do we come to this number, 272? What is the basis of calculation of this 272 for Lok Sabha. What is the basis? All of this is provided under the Constitution of India. Okay, so let's go through these different provisions here. So first is very simple majority. So it says it refers to a majority of the members of the house present and voting. And see, this type of majority we need to understand on the basis of example. For example, total strength is to 545 of Lok Sabha. Let's say on a given day, number of members present are 290. So votes needed for any law to be passed by simple majority would be 290 divided by 2 plus 1. So this is simple majority. Number of members present and voting, that is half plus 1, that is the requirement of simple majority. So let's see where these simple majorities are required under the Constitution of India. Passing of ordinary bills, money bills and financial bills, passing of adjournment motions, etc. So for all these purposes simple majority is required. What is the meaning of simple majority? That whoever the number of people present on a given day, uska half plus 1. Okay, so it does not include the members who are absent. So absentees are not included. Absentees not included, and it does not matter also. Please understand there is a concept of quorum. Okay, quorum means the minimum number which should be present in the Lok Sabha for which or based on which proceedings can continue, and the minimum quorum is 10% of the total strength, and hence the quorum for Lok Sabha comes to 55. So if there are 55 at least members, then voting can take place or proceedings can take place. Similarly, election of speaker and deputy speaker of Lok Sabha takes place through this concept of simple majority. Okay, election of deputy chairman of Rajya Sabha, same, simple majority. Passing of a resolution by Lok Sabha for disapproving the continuance of national emergency, this is also done by simple majority under Article 352. Approval of imposition of President's rule under Article 356 done by simple majority, and then approval of proclamation of financial emergency also under Article 360. So these are the different types or provisions under the Constitution of India whereby the type of majority or type of voting required is simple majority. Are you following this, Krishna? Amrutesh, I hope you understand, correct? Then comes absolute majority. Now see, there is a difference between absolute majority and effective majority. Let's understand this. Now absolute majority says it refers to a majority of the total membership of the house and includes vacant seats or absentees. Total membership, it doesn't matter who is absent, who is present, whether the seat is vacant or not. When does a seat becomes vacant? When either the member has resigned or the member has died, or for whatever reason the person present is not there. So in total membership of the house, it includes both vacant seats as well as absentees. और कैसे calculate करते हैं इसको? For example, since the total strength of Lok Sabha is 543, the absolute majority for Lok Sabha is 543 divided by 2 plus 1 is equal to 272. Can you find a magical number here? So what is the type? ये क्वेश्चन कभी भी आ सकता है आपके प्रीलिम्स में कि for formation of government for the general election, what type of majority is required? Most people will commit a mistake and they will end up writing simple majority. It's not simple majority, it's absolute majority. ठीक है? And what are the various examples? To form the government at center and in states, to defeat no confidence motion, and also acts as a component of special majority. ठीक है? Are you following absolute majority? So you'll remember next time. Formation of government, defeating no confidence motion requires absolute majority. Effective majority. Now it refers to a majority of the total membership of the house excluding the vacant seats. अगर कोई seat vacant है, if the seats are vacant, then they will not be included while counting the votes. How it is calculated? For example, suppose 25 seats are vacant out of the total number of seats in Lok Sabha. So in this case, effective majority is equal to 543 minus 25 divided by 2 is equal to, or plus 1 is equal to 260. So basically, whatever the seats, the number of seats, whatever they are vacant, they will be subtracted from the original number of seats. कृष्णा CSAT कर रहे हो, +1 का मतलब वही होता है. Suppose 240 members are there in Rajya Sabha. Suppose, चलो 250 लेते हैं, ओवरऑल 250 ही है. 250 members in the Rajya Sabha. Okay, 20 are absent. How much remains? 250 minus 220 is 230, right? So to calculate absolute effective majority, it would be 230 divided by 2 plus 1. So it would be how much? 115 plus 1 is equal to 116. This is the meaning of plus 1. This is your effective majority here when 20 seats, sorry, are vacant, not absent. 20 seats are vacant. Krishna, how do you understand meaning of plus 1? सिंपल मैथ्स, हाफ का हाफ करो, उसमें एक और जोड़ दो, तभी तो मेजॉरिटी आ पाएगा. हाउ विल यू कम टू, हाउ विल यू, you know, how will you calculate the majority? You have to always add 1. Okay, so this is your effective majority. Please quickly calculate absolute majority for this number. Tell me the absolute majority for, if Rajya Sabha has 250 members, then what would be the absolute majority for Rajya Sabha? Quickly. This is pure CSAT, nothing else. And I'll tell you why I'm discussing this. This year only a question has been asked in your prelims. Yes, what would be the absolute majority here? (126). Perfect. I hope all of you understand how it is 126. Simple, 250 divided by 2 plus 1, because we include both vacant seats and also absentees in total, in absolute majority. See this? And includes vacant seats or absentees. And where effective majority is used, it is used for removal of vice president in Rajya Sabha, for removal of deputy chairman of the Rajya Sabha, and removal of speaker and deputy speaker of the Lok Sabha. ठीक है? Is it clear? Is this helping you, this bifurcation, this diagram, to make you further understand? And what are these? We will only be able to understand when we'll start the chapters on parliament and how the parliament functions. No. Abstain कर दिया तो vote नहीं किया ना. See, this concept of abstain from voting is mostly, Fatima, available, understood mostly under international law than under our law. So let's say someone did not vote, so it's not counted as a vote. would be considered as a neutral thing. Now comes special majority. Now please understand certain aspects regarding special majority. Please, special majority. One more thing, please know this. In Lakshmikant or in any standard textbook, जब आप पढ़ोगे, even NCERT, you'll come across these terms like simple majority, effective majority, absolute majority, total membership, or special majority. But these terms are not mentioned in the constitution. I am telling you outrightly, these terms like simple majority, effective majority, special majority, especially these terms are not mentioned in the constitution. Rather, how they becomes operative, that is mentioned. So these terms are not mentioned in the constitution. So this can also be asked in your exam. These terms are not mentioned in the constitution. Please understand this. Clear? Coming to special majority, it has 4 types: type 1, type 2, type 3 and type 4. Type 1 deals with Article 249. Type 2 deals with Article 368. Type 3 deals with Article 368 plus entrenched provision. And type 4 deals with impeachment of president. And yes, these 4 types are different. They operate in a different manner. Okay? These 4 types are different. So let's understand these different types of special majority. So how many types of special majority are there? There are 4 types of special majority. Don't get confused. If you read anywhere, ठीक है, this is done by special majority, think कौन सा special majority? बहुत सारे special majority. This is also a place where student often get confused. Very easily UPSC can lay a trap for you just simply writing this is done by special majority. Think. So let's go through these different types of special majority. पहला क्या है? Type 1. Special majority as per Article 249 requires a majority of 2/3 of the members present and voting. Just an example. It simply says, let's say if there are 99 members, for the sake of calculation, if there are 99 members, then what would be the type 1 special majority? 2/3 of the members present and voting. How much would be? Correct? Right. So Article 249, power of Parliament to legislate with respect to matter in state list in national interest. So generally Parliament does not have power to make laws on state list, but under Article 249 in national interest Parliament can do so. But for that purpose a law needs to be introduced in the Council of States, that is in Raj Sabha, and must be passed by what type of majority? Type 1 majority. So type 1 majority mentioned under Article 249 requires majority of 2/3 of the members present and voting. We'll discuss this more elaborately obviously when we'll take up Article 249 and associated matters. But please understand that type 1 majority mentioned under Article 249 requires majority of 2/3 of the members present and voting. This is important. Present and voting. Next, special majority under Article 368. I think this is what you were asking yesterday, Krishna, right? So type 2 is a type of majority mentioned under Article 368. What does Article 368 says? Requires a majority of 2/3 of the members present in voting supported by more than 50% of the total strength of the House. And here the word generally used is total membership of the House and as in plus 2/3 of the members present in voting. So this is your type 3 special majority mentioned under Article 368. Obviously, type of majority required to pass a normal constitutional amendment, and this type of majority is also required not only for constitutional amendment but also for removal process of Supreme Court, High Court judge, CAG, Comptroller and Auditor General and CEC. ठीक है, सेम ही प्रोसेस है. Clear? Krishna, is this clear now? Amrutesh, Fatma? So, to pass a constitutional amendment bill that does not affect federalism, removal of judges of Supreme Court, High Court and removal of CEC and CAG. ठीक है. Now comes type 3. Type 3 में कुछ नहीं है, बस ये जो type 2 था, type 3 is equal to type 2 plus this. It needs to be passed by half of state legislatures or at least half. मतलब अगर how many states are there in India? How many states? 28. So it must be passed by at least 14 states. अब स्टेट किस टाइप के मेजोरिटी से पास करेंगे इसको? स्टेट इसको पास करेंगे सिंपल मेजोरिटी से. स्टेट इसको पास करेंगे सिंपल मेजोरिटी से. स्टेट विल पास दिस बाय सिंपल मेजोरिटी. ठीक है. दिस इज इंपॉर्टेंट. व्हाई? दिस एक्स्ट्रा cushion, extra protection is given because it affects powers of state also, and hence approval of at least 50% of the states are required. And what are these manners? What are these matters? And these are called entrenched provision. What are these? Manner of election of the president. If there has to be a change, an amendment in the manner of the election procedure of the president, then it must be passed by type 2 plus at least half of the state legislature should also approve it. Extent of executive power of the union and states. Supreme Court and High Courts, anything associated with Supreme Court and High Court requires this because it is a federal feature. Distribution of legislative, administrative and taxing powers, basically all the relations between center and states, any aspect. Representation of states in parliament, an amendment in Article 368 itself. So if you have to amend Article 368 itself, you require this type of amendment. ठीक है. Now quickly tell me, I am giving you this point that GST bill, when Constitution 101st Amendment bill was passed regarding GST, 101st it was, yeah, then it required type 3 majority, had to be approved by half of the state legislature. My question is, why do you think this type of majority was required to pass the GST bill by the central government? ऐसा क्या था GST में? Why was that needed? Yes, please. Yes, Fatma. You can speak. Anyone? Basic bath. See, always know the basics. Always ask the basic questions. It's not the complex matter which kills us, it's the basics which actually kills us. Earlier, state had power to collect VAT और सेल्स टैक्स. ये पावर सेंटर को नहीं था. सेंटर डिड नॉट हैड दिस पावर टू कलेक्ट वैट और सेल्स टैक्स. सेंटर अर्लियर हैड पावर टू कलेक्ट सर्विस टैक्स and then appropriate the proceeds with the states. But states did not have power to collect service tax. Now GST regime, जो GST regime था, it envisaged a mechanism whereby both center and states needed to collect both these taxes. That is VAT. Center also you have to collect sales tax and of course service tax to thai. And similarly for states. तो स्टेट के पास तो पहले सेल्स टैक्स का पावर था ही, बट सर्विस टैक्स का पावर नहीं था. एंड हेंस टू गिव बोथ सेंटर एंड स्टेट्स टू कलेक्ट, फॉर सेंटर टू कलेक्ट सेल्स टैक्स and for states to collect service tax, this type of amendment was required because this also required an amendment in union list regarding powers under central list and state list and also concurrent list. Since it affected center state financial relations, which is also one of the entrenched provision, that's why along with type 2 majority 50% of state ratification was also needed. Clear? Basics, absolute basics I'm telling you. How center collects tax, how GST is there, what are the different aspects of GST compensation funds, we'll discuss later when we'll talk about GST or the financial relations. वो भी पढ़ना जरूरी है because basics we need to know. But is this point clear? You'll generally don't get this under any books. Okay. So are you, and okay, and type 4 majority is removal of precedent or impeachment of precedent. And क्या है इसमें? Special majority as per article 61 requires a majority of not less than 2/3 of the total membership of the house. So it is total membership of the house. What is the total membership of the house? Quickly. This is your type 4 majority. How much? Calculate करो. 396. Sure? $543, $250. How much? $743, $793, $397. ठीक है, somewhere around. So no absentees needed or no absentees recorded, no absentees or vacant seats, none of them are counted. ठीक है, क्लियर है? डिफरेंट टाइप्स ऑफ मेजॉरिटी. लेट्स मूव फर्दर. This is your question asked in prelims 2025. Now quickly answer this. Question is, consider the following subjects under the Constitution of India. List 1, Union List in the 7th schedule. Second, extent of executive power of a state. Third, conditions of the governor's office. The question is, for a constitutional amendment with respect to which of the above ratification by legislatures of not less than one half of the states is required before presenting the bill to the President of India for assent. Is it relatable for whatever we have discussed? कृष्णा इतना जल्दी आंसर नहीं करते, थोड़ा पढ़ते हैं आराम से. ये गलती नहीं करना एग्जाम में. Read carefully. It's a UPSC question. It has some trick. And by the way, why did you come to the conclusion B? 2 and 3? Give me reasons. So let's take it step by step. Is first an entrenched provision. Basically, simple question ये है कि it is asking which of them is an entrenched provision requiring type 3 special majority. Simple. Does first point requires a special majority? Any amendment in union list in the 7th schedule? See, unless you answer, there is no point of this class then. Please interact. कोई फायदा नहीं है, trust me. I will stop taking classes if you do not interact. Just now I explained you about the GST thing. Do you think any changes in list 1 or the union list needs a ratification by at least half of the state legislatures? Yes. So 1 is correct. Second, extent of executive power of the state. Let's go through the provision again. Extent of executive powers of the union and states. See, can you see this, what is written here at least? Yes. Conditions of governor's office. कहाँ लिखा है ये? कहाँ है? गवर्नर के बारे में कुछ भी नहीं है. Again, Krishna, you are hurrying with the answer. Don't go for the answer. Go for the reason. Answer is not important. The reason with which you come to your conclusion is important. A, B, C, D is not important currently. You have a lot of time to develop, to give various mock tests. As of now, the purpose why I am showing you these previous year's questions is to make you understand the mind of UPSC. How UPSC plays trick with you. How it lays trap for you. You have to understand those traps and avoid those traps. Okay. Nowhere here there is any mention of the governor. So very easily, if you remember, then you can cross this. So what are the options left? 1 and 2. कौन सा है? A. Tell me, is this question was really that difficult? See, if you are really serious about UPSC, this is not a difficult question. It's not difficult. Honestly, it's not difficult, but obviously you have to know the concepts. I'm here to make the concepts easier. You can study by yourself. I know that. But I also know after you complete your revision by yourself, there would be infinite number of doubts which you will have. And if those doubts are not solved, trust me, no matter how much you revise, it will not be of any help, because ultimately आप गलती ही करोगे एग्जाम में जाके. क्यों? क्योंकि doubts, क्योंकि concepts clear नहीं होंगे. So whatever classes we have, 50 odd classes, try to be interactive, try to take help, because I will not repeat these classes again and again. You may be able to watch the recorded lectures, but nothing more than that. It's better to have a live interaction. You actually develop your concepts. So please utilize these 2 hours. Okay, simple question asked by UPSC. If you may allow, can we discuss today some of the UPSC questions asked in the prelims, just to give you an understanding that how we need to study fundamental rights. Nothing more. Fundamental rights, we have gone through, like, you know the basics now. There are certain rights which you can go to the court and all those things, you know, आपको सब पता है. Now let's understand the quality of fundamental rights with respect to the quality of questions asked by UPSC. Is it okay with you all? Amrutesh, Fatma? Let's go through some of the questions. So I've taken some of the questions today so that I wanted to discuss that whatever we have discussed so far, let's take up some of the, let's consider it as your test. UPSC 2012, the question is, the distribution of powers between center and states in the Indian Constitution is based on which of the following? Is based on the scheme provided in which of the following? The distribution of powers between center and states in the Indian Constitution is based on the scheme provided in the, options are Morley-Minto Reforms 1909, Montagu-Chelmsford Act 1919, Government of India Act 1935, Indian Independence Act 1947. Now I have discussed this with you. I expect you to answer this particular question. Amrutesh, you have been attending all the classes. Fatima, even Krishna, please answer this question. Again, this is talking about center-state relationship. Fatma says Government of India Act 1935. Do all of you agree with her? Give me a consensus answer, common answer. Anyone disagrees with Fatima? This is correct. 2018, in the federation established by the Government of India Act 1935, residuary powers were given to the, options, Federal Legislature, Governor General, Provincial Legislature, Provincial Governors. Although we have not discussed residuary powers, the correct answer here is provincial governors, but we'll discuss residuary powers later. See, residuary power means whatever power is there in the 7th schedule, powers are like union list, state list and concurrent list. So in this number of entries are provided, in this number of entries are provided, and in this number of entries are provided. And it's also possible that there are some issues which could not be thought of, which could not be envisaged while drafting the constitution. And hence those aspects which are considered as residuary powers are given to the center or to the parliament. Are given to the parliament under entry 97. Under entry 97 of union list. But in the Government of India Act 1935, this residuary powers was vested with the provincial legislatures, basically with the governor. Okay, that is the idea. Next question. In the 2019, in the context of polity, which one of the following would you accept as the most appropriate definition of liberty? Now I want you to go through the statements and think about it. Options are protection against tyranny of political rulers, absence of restraint, opportunity to do whatever one likes, and opportunity to develop oneself fully. What do you think should be the correct answer here? Whatever. See, the statement is a very qualified statement. Whatever you feel like, anyone can feel like murdering someone. Is that allowed? Cannot do whatever you feel. Today I want to drive my car at 200 kilometers per hour on the road. हो गया accident. Am I allowed to do whatever I feel like? No. There are reasonable restrictions. हाँ, now comes the controversy between B and D, absence of restraint, an opportunity to develop oneself fully. This question basically highlights the dichotomy between the concept of liberty. Liberty, Amrutesh, you were there in the last class, right? I discussed about two aspects of liberty, one positive, one negative. So, dono hai. When we talk about liberty, both aspects are there. Positive aspects are also there. You are free, you are at liberty, let's say, to pursue your civil services dreams. You are liberty to not pursue civil services dreams. You want to go back to your respective profession, you want to go back to your job, fine, you are at liberty to do so. An absence of restraint. Now this also is slightly, uncouched words. Meanings, let's say if there is absence of restraint, there is no restraint, then you are free to do whatever you feel like. इसमें और इसमें बहुत फर्क नहीं है. B और C में, it's just written in a different manner, hardly there is any difference. See, absence of restraint is no restraint whatsoever. An opportunity to do whatever one likes is almost similar. So the correct form or correct understanding of liberty is in a positive connotation to develop yourself. Opportunity to develop oneself fully. So in this, the correct answer would be D. Now this was one question asked in 2018. Rule of law index is released by which of the following? That was in news at that point of time, and hence that was asked. Just understand, the correct answer here is D, World Justice Project. Just write this down. World Justice Project releases rule of law index based on certain parameters. So we need to study rule of law from this point of view. I'm just giving you a backdrop to what sort of questions has been asked so far under fundamental rights. Rule of law index is published by World Justice Project. Rule of law index is published by World Justice Project. As of now, just remember this. Let's take up another question on rule of law. Which of the following are regarded as main features of rule of law? Now, I want you to discuss one by one. Limitation of powers. Do you think yesterday we would, in fact, we devoted one whole lecture on rule of law and its correlation with democracy and democratic values, decentralization of power and everything. On that concept, just think. See, these are all conceptual questions, and I have discussed everything whatever I have taken in today's discussion. These questions as well. Amrutesh, you were there. Krishna, you were there yesterday. I hope you remember the discussion. So rule of law, can we at least say there is limitation on power? Yes, please. All of you agree for the first point? Correct. First is correct. Second, equality before the law. करेक्ट. तो 1 and 2 कहाँ कहाँ है? सिर्फ यहाँ है, C में है और D में है. ठीक है? That's how we calculate the options. So if you're sure about 1 and 2, just see where you have 1 and 2. So what options you are left with is C and D. So you have to choose between C and D. So you can cross out, you can vote out A and B outrightly. See, people's responsibility to the government, and 4, liberty and civil rights. So between 3 and 4, which do you think is a more appropriate answer? Or both are perfect? What do you think? Four, correct. This is not. So correct answer then becomes C. That's how we come to the right conclusion with respect to any question. I'm also teaching you literally how to go through a question asked by UPSC step by step. A, B, C, D से नहीं जाता है, आता है आंसर, ऑप्शन से आता है. You have to work out the options. only then you will be able to work out the answers. Options as in 1, 2, 3, 4. Generally the UPSC questions are based on like this only. Very rarely a question like this appears, but this is not an easy question. Please, can you tell me the correct answer here? One of the implications of equality in society is the absence of. See, all we are discussing so far is equality, liberty, the basics. So let's understand the basics first and then correspond the basics along with the constitutional provision. That's the idea. And today I have taken extracts from NCERT also. In fact, we have been discussing Lakshmikant, NCERT and a constitution. It's sort of a mix of these three. I don't outrightly tell you that we are discussing this and this, but more or less it's a crux of your NCERT books, Lakshmikant, and of course the Constitution of India. Which one? One of the implication of equality in society is the absence of. देखो, ये वाले क्वेश्चन को आंसर करने के लिए कुछ भी पढ़ने की जरूरत नहीं है. All you need to do is, to be an aware citizen. That's all. Especially if you are preparing for UPSC Civil Services, you need to be slightly aware. A. Krishna says A. Amrutesh, Fatma, do you agree? A. Okay. Tell me, why not restraints or why not competition? What's the problem with restraints or competition? There could be reasonable restraint, but that does not mean the society is any less equal. Competition, if you restrict competition, definitely it will restrict equality. But absence of competition itself does not mean that there would be an unequal society. Socialist state, they rarely have competition, but yet their societies are much equal. So in this regard, the correct answer here would be privileges. A. Because if you give privileges to someone, it means you are discrimination. Privileges is also an element of discrimination. Do you agree? Privilege is also an element of discrimination. आप एक को privilege दोगे, obviously इसका मतलब आप दूसरे को discriminate कर रहे हो. Do you agree? And in that sense, another rather a controversial issue, can we say that reservation is a privilege? Can we say reservation acts almost like a privilege? No. ठीक है. We'll talk about that later. But the correct answer, yes, is privilege. Why reservation is not privilege? Because it does not act as a discrimination in the society. It's sort of an affirmative action by the state, positive action by the state. A very interesting question is this. 2020. Just look at this question. I wanted to discuss few things about this. One common agreement between Gandhism and Marxism is. One common agreement between Gandhism and Marxism is A. The final goal of a stateless society. B. Class struggle. C. Abolition of private property. And D. Economic determinism. What do you think is the correct answer here? Why, Amrutesh? Fatma, what about you? What do you think is the correct answer? C. Okay. And Krishna, any view on this? See, it's not necessary to attempt this question also. Agar tough lage, if you don't understand, just leave it. You're not supposed to attempt 100% of the question. I think A. Okay. A is correct. And both Gandhiji and Marx believed in a stateless society. Ideology of Marx was that one day state would wither away. And this was one commonality between Gandhism and Marxism, and that's why Gandhiji suggested for a village republic whereby the effective control is in the direct hands of the people. Yeah, go back to the local governments, correct. So you see, a very conceptual based questions are also asked by UPSC. This one, 2021, a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of the application of law violates which one of the following articles of the Constitution of India? Such an elaborate definition of which of these articles? For that you have to know the article, of course. But in general, what is the meaning of this? A legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following? Have you heard about a concept known as PNJ? Amrutesh? Fatima, have you heard? Okay. Principles of natural justice. This statement is a combination of many concepts. Many concepts. See, it's important to understand principles of natural justice because principles of natural justice is the wider umbrella. It is the wider umbrella जिसका एक पार्ट बनता है रूल ऑफ लॉ. One part of it is rule of law. At the very outset, I am telling you this fact that rule of law is a concept given by A.V. Dicey of Britain. And in India, we exactly do not follow rule of law as propounded by A.V. Dicey. Okay? In India, we do not follow the concept of rule of law exactly as propounded by rule of law of A.V. Dicey, but we have made certain additions. So Indian concept has provided certain additions to the British concept of rule of law, and this addition is based on American jurisprudence or American laws. So whatever addition we have provided is based on American version of understanding of due process. And overall सबसे बड़ा अम्ब्रेला क्या है? Equality. Okay. Two important principles of natural justice are: first, rule against bias. Simple example being, if someone is biased, prejudiced, and then he is also asked to decide on that matter, do you think it would be a fair judgment? Let's say a judge has some shares in XYZ corporation. Okay? And that case of that XYZ corporation comes before that judge only. Do you think he'll be able to decide that case in a fair manner? So there are various aspects of rule against bias. Someone can be biased based on financial aspects, blood relation. Suppose करो UPSC के board में, let's say there is a UPSC board for interview. UPSC board for interview, ठीक है? And in this board, one of the members daughter sits before the board. So basically a daughter sits before his father and is giving interview. Do you think that interview is fair? No. Of course not. So principles of natural justice is a wider application, or rather an application of the concept of equality. And equality also means that there shouldn't be arbitrariness. So a concept है that equality is antithesis to arbitrariness. Antithesis to arbitrariness. Okay. And the second principle of natural justice is this: rule against fair hearing. That is, no side shall be condemned unheard, meaning a judge cannot give a judgment only by listening to one side of the story. Why, there are two sides to a dispute. You do not give any opportunity to the other side of the disputant to present his case. What does it mean? Biasness, arbitrariness. And another important element of natural justice is reasoned decisions. The decision must be based on reason, not an arbitrary thinking. Okay? Okay? So overall, this is prevalent not only under equality but also in the concept of India's Article 21, which we will discuss in detail. But are you able to understand the concept of principles of natural justice? I think I forgot to bring that question. If you could see, there's a question asked on principles of natural justice in, I think, 2024 prelims. I think so. A direct question on principles of natural justice in 2024 prelims. Okay. So correct answer here would be this: equality. See this: a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power. So the moment you say unguided and uncontrolled discretionary power, it means the administrative authority has all the powers to decide whatever they feel like, and hence it fundamentally attacks against Article 14 because such decisions would be arbitrary. So this whole concept is based on this understanding of arbitrariness. So through these questions, what I have tried to do with you all is that I have tried to give you certain ideas. I have inserted certain ideas in your brain. Think about these ideas. Okay? Moving further. अच्छा और है? चलो देख लेते हैं. 2017, in the context of India, which one of the following is the correct relationship between rights and duties? See, always remember, rights and duties are correlative. We will discuss about this later, but please write this. Rights and duties are correlative. Rights and duties are correlative. And to this question, I would like you to just read this. As of now, just read this question. We will try to solve this. Which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? ठीक है, क्वेश्चन क्या है? Which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Very clearly, what UPSC expects you to know is this, that you know all these aspects. For example, that under right to equality, what are the different rights which has been covered? So right to equality includes equality before the law, prohibition of discrimination on various grounds, equality of opportunity in public employment, abolition of untouchability and abolition of titles. तो ये कहाँ आया? Abolition of untouchability यहाँ आया. This one. I think this was the exact question asked. Let us check. Protection against untouchability as a form of discrimination. So the correct answer would be right to equality. So these type of questions are also asked, that you have to locate a particular fundamental right with respect to the broader fundamental rights. So under fundamental rights chapter, broadly speaking, there are 6 categories of fundamental rights, and within those 6 categories there are further subcategories. Okay? I just want your opinion right now, that through these questions, I think we have discussed 10 or 12 odd questions. Have they helped you to understand how UPSC tries to ask question? What is your takeaway with respect to this discussion? I just want your opinion, frank opinion. Has it helped you? Has it not helped you? Or it has given you certain insights about UPSC? Amrutesh, what about you? Because based on this, we will further take up various other matters or discuss other aspects of the class. So what did you learn, Amrutesh? क्या सीखा आपने? Fatima, what did you learn? Krishna, what did you learn? Correct. All of you are correct. It shows what to expect from UPSC, and absolutely, you know what is the correct full form of UPSC, as in a very joking way, Unpredictable Service Commission. Yes, the questions are covers a wider dimension and at times also cover the minute details. Absolutely correct understanding of questions, and that's how you need to study. So through these questions, what I've tried to do today, yesterday I discussed questions from mains to give you an analytical understanding of the topics. Today I've discussed questions from prelims to give you to show you the mirror. Let's see, this is what is required, so prepare accordingly. It's totally up to you. I'm here to teach, I'm here to discuss the fundamentals. It's totally upon you how you or what you take from these classes, how you take from these classes. I would suggest be present for these 2 hours, try to manage that. I'm sure it will yield dividends for you. That much I can guarantee. Because the type of questions which are asked both in your pre and your mains are conceptual based questions. Just going through NCRT or Lakshmikant is not enough. It's also important to understand the concepts. I'm sure you must be going through some of various videos of toppers. I was actually going through one of I don't exactly remember her name or rank. She was somewhere around mid 30s, All India rank 34 or something. This girl said, see, yes, Lakshmikant is important, but please understand that's not the only book. And just by reading Lakshmikant, don't expect to solve answers in your prelims. And I will also say the same. Is it a good book? It's a very good book for fundamentals. But is it enough? No. Is NCRT good book? Very good book. Is it enough? No. Is Constitution of India a good source? Yes. Is it enough? No. It's an amalgamation of all these 3. So it's an understanding of these three which will further help us to clear the exam. One more thing, I also happened to go through some of these lectures, from by other faculties, and also try to learn, try to understand, so that I could teach my students. The one thing which this was being said by very senior faculty was that, see, GS2 of late, especially by which the type of questions asked by UPSC in the mains, has become very unpredictable because it is based on a lot of current affairs. The incorporation of current affairs or the element of current affairs in your GS2 questions has slowly increasing. Earlier it was only about roughly 20 to 25%, but now it has stretched up to 60%. So the point I am trying to highlight here is that, first, newspaper is important. How many of you go through the newspaper every day? Amrutesh, Fatma, Krishna. In the process, we have also started a weekly current affairs lecture. I'm sure you must be seeing that. At least follow that. It's a weekly current affairs. So far I think I have taken up 3 lectures on polity, covering around 8 important developments. जैसे अभी बिहार में आपका वो आया है ना, SIR, systematic intensive role, that is for electoral roles, or this concept of secular or socialist in the preamble, not in the preamble. So I try to take up most of the important news every week. Try to go through that weekly current affairs also, and this is also done in different subjects. By Akshay Sir. Akshay Sir takes these weekly lectures for environment and science and tech, and as of now Jatin Sir is taking for economy. So my suggestion to you is, please go through these topics. It's a weekly affair, so every day just you have to watch one lecture. I think that is good enough. But please have an idea of relevant developments. Or you can say current developments. What current developments? Those current developments which are associated with your syllabus. Today in the Hindu newspaper, one article has appeared with respect to powers of governor. Please go through that. So slowly also develop yourself. This is very important. So GS2, particularly polity and international relations both, is now what we are seeing is more dependent on current developments. I will try to take up whatever current developments happen in these 3 months or whatever has happened in the past. No doubt about that. I'll try to take up. But I cannot take up those current developments which will happen post September. क्योंकि class तब तक खत्म हो जाएगा, है ना? But I'll try to, I'll be continuing these weekly current affairs development videos where you can definitely watch them. Yeah, sure. Yes, Amrutesh. सबसे पहले regarding polity, I'll say this, that, and I'm not making any controversial statement, but please stay away from this. Stay away from politics. BJP said this, Congress said this, Trinamool party said this, or that party said this. No, not needed. What you need is basically, if there are any major headlines relating to your part of the syllabus, major headlines regarding any part of your syllabus. Suppose, for example, just giving an example, recently a very bad and unfortunate crash happened for Air India, right? Can you locate this crash in any part of the syllabus? So for that, you need to know the syllabus, right? And then major headlines, and then editorial section is important. Editorial or article section. बेसिकली द ओपेट सेक्शन जिसको बोलते हैं हम लोग, generally appearing either on page 6 or 8 of the Hindu newspaper. This is something you must read every day. In this, there is another section called, I think, context section. The very next page is your text and context, not context, text and context. And then Indian Express, you have explained. So only those topics which you think is again important from your syllabus. So try to read those articles which corresponds to any part of the syllabus. Let's say an article appears on poverty, please go through it. Let's say an article appears on census, please go through it, because those are part of your syllabus. Let's say an article appears on inflation, please go through it, it's part of your economy syllabus. Let's say an article appears on archaeological survey or any site being discovered, of course, part of history. कभी कभी history में भी current development से पूछ लिया जाता है, based on whatever has developed or whatever has appeared in the news. Polity, तो obviously you will know. I'll try to keep you updated as far as possible. Okay? At least you got some idea. And better, I would say, start watching these news, weekly current affairs lectures, so that at least you have a basic understanding of these lectures. What I'll do after this class, I'll forward the lectures which we have already recorded. It's there on the YouTube, it's free, so it's for everyone. I'm telling you because it's our initiative. This is what we have done at PMF IAS. So I want you to take benefit of it. Any other doubt, any other concept today? Today I think I've taken more of a sort of a discussion class based on PYQs and some of your doubts. And also I've also tried to show you that see, this is the reality. I'm giving you sort of a reality check. कि देखो यही reality है. No matter whoever tells you what, whoever says you whatever things, be informed. That's the only thing. Be informed about the syllabus, be informed about the current developments, be informed about the topics at hand, and have basic conceptual clarity. And keep this in every subject. Don't go on the complexity of the topics. Try to understand it in a basic manner. Constituent assembly है तो constituent का मतलब क्या? Amendment हो रहा है तो क्यों हो रहा है ना? What is the need for an amendment? क्या जरूरत आ गया amendment का? ठीक है? Okay. Let's move further. So let's now take up the elaborate explanations with respect to, see again, this I have taken from your NCERT books, class 11 particularly, if you want to ask, if you want to know that. Let's go through each of them, what has been provided in NCERT, and then we'll take up the provisions under the Constitution, and then followed by Supreme Court judgments. Okay, that's how we will understand fundamental rights, because Supreme Court has actually expanded the various concepts. Everything is not written in the Constitution. Constitution simply says one line, and Supreme Court has given a very wide, harmonious construction, liberal interpretation, expanded the ideas for what purpose? To ensure that rights of citizens are not infringed, so that arbitrary decisions are not made by the government. है ना? So let's go through this right to equality. It says equality before law and equal protection of the laws. So two types of equality is highlighted. It then mentions about prohibition of discrimination on these different grounds of religion, race, caste, sex, or place of birth. So discrimination is not possible, is not allowed. Equality of opportunity in public employment. So let's say you are appearing for public services, there is equality of opportunity, and on this ground government cannot discriminate. Just because you're a woman, you cannot be disallowed to write an exam. Abolition of untouchability and abolition of titles. So these are part of your right to equality. Right to freedom includes protection of right to freedom of speech and expression, assemble peacefully, form associations, or unions move freely throughout the territory of India, reside and settle in any part of India, practice any profession or to carry on any occupation, trade or business, whatever you feel like. Protection in respect of conviction of an offences. Let's say if someone is about to be arrested, then what are the rights of such person who is arrested? Right to life and personal liberty, right to education, protection against arrest and detention in certain cases. So this comes within right to freedom. और क्या है? Then comes right against exploitation, prohibition of traffic in human beings and forced labor. That is, slavery is prohibited, begar is prohibited, or any form of servitude or bonded labor is prohibited, and government has made laws on that also. Prohibition of employment of children in hazardous jobs, but for this certain age criteria is given, so that is something which we need to know. Right to freedom of religion, too, we have seen in detail. Freedom of conscience and free profession, practice and propagation of religion, freedom to manage religious affairs, freedom to pay taxes for promotion of any particular religion, freedom to attend religious instruction on worship in certain education institutions, cultural and educational rights for protection of language and culture of minorities, and right of minorities to establish education institutions, and right to constitutional remedies with respect to moving to Supreme Court in case your fundamental rights are infringed. So just write these, that on an यहाँ से लिख लो कि under the fundamental rights, just write this. Fundamental rights under part 3. Fundamental rights under part 3 can be categorized into 6 components. Can be categorized into 6 components, comma, each of which contains multiple rights. Fundamental rights can be categorized into 6 components, each of which contains multiple rights. First, right to equality. Second, right to freedom. Third, right against exploitation. First is your right to equality, second is your right to freedom, third is your right against exploitation, fourth is your freedom of religion, right to freedom of religion, and fifth is your cultural and educational rights, and sixth, is right, fifth, cultural and educational rights, and sixth, right to constitutional remedies. Sixth, right to constitutional remedies. Okay, 6 components, 6 major components of fundamental rights. Right. After this, other than these 6 components, part 3, other than these 6 components, part 3 also comprises of Article 12, which provides definition of state, Article 12, which provides definition of state, Article 13, which gives powers of judicial review for laws which are inconsistent with part 3, and Article 13, it gives power of judicial review for such laws which are inconsistent with part 3. And Article 31A, 31B and 31C provides for laws for acquisition of certain private property. Acquisition of certain private property so as to implement some of the directive principles of state policy. Okay? So this is your proper elaboration of fundamental right under part 3. So it includes 6 components, and other than that, article 12, 13, 31A, 31B and 31C. Clear? So this is your whole umbrella of fundamental rights. So a question like this can be asked in your mains examination, a 10 marker, that elaborate upon the various fundamental rights mentioned under part 3 of the Constitution of India. So this would be your answer. Obviously, और भी अगर कुछ याद रहे तो लिख देना, like article 14, 19, 21, which when we will study, I'm sure you will get a better understanding of how to write this question. But please write this question. This is your practice question. Enumerate the various fundamental rights provided under part 3 of the Constitution of India. Okay. Oh, sorry. Enumerate the various provisions under part 3. Enumerate the various provisions of fundamental right under part 3 of Constitution of India. This is a 10 marks question. ठीक है? All right, so let's move to the first part, that is state. Have you heard this concept before about the state? So let's go through article 12. It says that in this part, so wherever it says in this part means part 3. Unless context otherwise requires, states includes government and parliament. So I'll write it here, whatever state includes. it includes government and parliament. What else? Parliament of India, government and state legislature of each states, and all local or other authorities. So local authority, this local authority is with respect to panchayats and municipalities. And other authorities. Within the territory of India or under the control of government of India. Now, two important terms comes with respect to this. First, these should be within the territory of India. And second, should be within the control of the government of India. So this is your definition of the term state under Article 12. Now, why is state important? It is important because whatever institution is categorized as state, they need to follow fundamental rights. They need to follow fundamental rights. Under Part 3. Under Part 3. So, do you think the public sector undertaking such as SBI, LIC or any of the PSUs, Coal India Limited, Telecom Regulatory Authority of India, Bharat Sanchar, any PSU, do you think the PSUs can be categorized as state under Article 12? What do you think? So the important point to understand is that this is very clear. Government and parliament, government and state legislature, local authority is very clear. The problem arises with this term, other authorities, because this term, other authorities, needs to be understood with respect to these two important terms. That are these other authorities within the territory of India, and are these other authorities within the control of the government of India? And when can we say that these other authorities are under the control of the government of India? है ना? How can we say that someone is in control? Two or three aspects we can say. One is the power to appoint or to dismiss. Then we can say that person is under control. If government of India has power to appoint or remove, then definitely we can say it's under the control of the government. Second, power to provide guidance or guidelines for administration. If government can give guidelines, okay, this is how you are supposed to work, this is how you are supposed to do your job, these are the guidelines which you have to follow. So then yes, it's a limb of the government. So that agency is associated with the government, part of the government. And third, of course, financial control. Does government of India provides financial security to that institution, or does that institution run based on the money given by the government of India? So these are the three aspects through which we basically try to find out whether other authorities under Article 12, can we say that these other authorities are part of state? Okay? Are these components clear to you with respect to state? Now see, earlier it was understood that state could only be such institutions, state as in under Article 12, could only be such institutions which are created either under the Constitution which are created either under the constitution or through an act of parliament or state legislature. So if any institution is created either by a constitution or by a statute, that is an act of parliament, then we can say that that authority or that institution or that agency is a state under Article 12. Okay? This was the earlier understanding. But later this understanding changed and it also included a third category. It also included a third category. The third category was that if an institution is constituted under Societies Registration Act, so these are the three criteria used to understand how are institutions created. So based on creation, we try to find out that how can we say which are other authorities under Article 12, which can be categorized as other authorities under Article 12. So पहला criteria क्या है? Based on creation or based on their constitution. Constitution would be the correct word. How are they constituted? Second test was based on their function. That what function did they perform? If, let's say, even if they are created by the parliament or associated with the government, but they are not performing in an associated governmental function, can we say that they are state, or can we say that they are other authorities under Article 12? So बाकी definition में कोई problem नहीं Article 12 के. The only problem which the Supreme Court has encountered is with respect to understanding or providing a clarity with respect to definition of other authorities. And different type of tests have been applied to understand the functionality of that body and also the constitution of that body. Is this clear to all of you? Yes, Fatma.
Sir, actually, the previous explanation regarding what state includes in the other authorities, so we saw that even regarding the parliament, government and local authority, that it should be within the territory of India and should be in control of government of India.
Correct.
So for other authorities, is it necessary the regulation of finances is in the hands of government, then only it would be counted under other authorities?
Yes, it is. So that was provided based on another aspect, that is control. So different type of test was highlighted. We'll go into some of the judgments. 2 to 3 judgments are important. R.D. Shetty versus Airport Authority of India. In that case, in R.D. Shetty case, basically it was highlighted that other authority can be constituted under Society Registration Act. And this provision, that an act of parliament or state legislature, was provided under state of Rajasthan, basically electricity board of Rajasthan versus state of Rajasthan. These judgments are not that important. All you need to know is the concept here first. Then comes the relationship. As Fatma, you have just highlighted, that is there a relationship? Is there a relationship between the government and this agency? This test was provided by R.D. Shetty case and also Ajay Hasia case, further elaborated upon P.D. Viswas case also. So this relationship between government and its agency or any institution which can be categorized as an agency of the government was further elaborated upon this by the Supreme Court judgments. So all these ideas which I have just told you, these were an elaboration by the Supreme Court. Why? Because the term other authority has not been defined under Article 12. Now this question can be asked in your prelims, that the term other authority under Article 12 has been defined under the Constitution of India. Nay, no. The word state has been defined, not the term other authorities under Article 12. It has not been defined, and the explanation can be seen under different judgments. So far, Fatima, so far clear the concepts?
Yes, clear.
Yeah. Let's go through the judgments to further understand. I've just given you sort of a backdrop to this entire story. So, it says that Article 12 defines the term state as used in different articles of Part 3 of the Constitution. It says that unless the context otherwise requires. अच्छा ये तो पूरा definition ही हो गया, ठीक है? Other authorities. अब local authorities कहाँ defined है? Local authorities has been defined under Section 3, Clause 31 of General Clauses Act 1887. Just remember these legislations and let's see what has been defined about local authority, because local authorities also state under Article 12. So this term local authority is defined under General Clauses Act, again not defined under the Constitution of India. The term local authority or other authority is not defined in the Constitution of India. It says local authority shall mean a municipal committee, district board, body of port commissioners or other authority legally entitled or entrusted by the government with the control or management of a municipal or local fund. Two words comes up here, control and management, because these words were also considered by the Supreme Court. So who is controlling and who is managing the affairs or the functioning of certain authority? It is the government. So at least government has certain control. Whatever that body is, it is being controlled by the government and also managed by the government. Supreme Court, it says, laid down the relevant test to determine the existence of state agency or instrumentality in different cases. If the entire share capital of the corporation is held by the government, obviously it is a part of the government, then we can say it's an agency of the government. It works for the government. Next, where the financial assistance of the state is so much as to meet almost entire expenditure of the corporation or that institution. So basically, regarding finance, it is dependent on the government. Next, whether the corporation enjoys a monopoly status which is state conferred or state protected. So has the state provided certain monopoly in its functioning? Whether the state has a deep and pervasive control over it. See this. How far the control is? Control over many things. Control over its functions, control over its officers, control over their appointment and removal, control over, let's say, following the rules, regulations, etc. If the functions of the entity are of public importance and closely related to governmental functions, do they perform any work for the government, for the public? And if a department of the government itself is transferred to a corporation, so in that case, a corporation, that is any public sector undertaking, can be said to be a state under Article 12. And yes, all the PSUs are state under Article 12. Okay? All PSUs are state under Article 12. Fatima, is this point clear? I think this is what you are asking. So in R.D. Shetty versus Airport Authority of India, court held that if a body is an agency or instrumentality of the government, it may be an authority within the meaning of Article 12, whether it is a statutory corporation, a government company, or even a registered society under the Societies Registration Act. And accordingly, it was held that International Airport Authority, which had been created by an Act of Parliament, was state within the meaning of Article 12. So, it no longer means that it has to be constituted by the created by the constitution or an act of parliament, but even if it is a society registered under the Societies Registration Act and it has all these elements. Further, this idea was further elaborated upon by this judgment. Achha, yahi hai. Test to determine whether a body is an agency or instrumentality of the government by R.D. Shetty. Same point almost. Financial resources of the state is chief funding source. That is, if the entire share capital of the corporation is held by government, existence of deep and pervasive control, state control, functional character being governmental in essence, function is of public importance. Same point. If department of government is transferred to a corporation and if the corporation enjoys monopoly status which is state conferred or state protected. In Ajay Hasia, the issue was that the case involved society registered under Jammu and Kashmir Registration of Societies Act, and this was running a regional engineering college in Jammu and Kashmir. So an engineering college was registered under the Societies Registration Act of Jammu and Kashmir at Srinagar, and this was sponsored by the government of India. See this word, sponsored by the government of India. So definitely there was an element of financial relationship, financial control. Then ingredients which weighed with the Supreme Court in holding the society to be a state, to mention the principal characteristics were the following. So Supreme Court held that yes, this engineering college registered under the Societies Registration Act is a state because of the following reasons. What were they? The composition of the society is dominated by the representatives of the government. So there is you can say too much of government representatives, and hence they represent the government on their behalf. The expenses of the society are entirely provided by the central government. So it's completely dependent on central finance. Rules made by the society require prior approval of the government. Society is required to comply with all the directions of the government. Government can appoint and remove members from the society, and thus an overall control is exercised by the government. Okay? Fatima, is your doubt clear now? Amrutesh, Krishna, what about you? Fatima, you have raised your hand. Any doubts again? Okay, other than that, there are certain institutions which has not been categorized as state. What do you think about NCERT? What about NCERT? जिसका हम लोग बुक पढ़ते हैं. Yes, please. What about NCERT? Is NCERT a state? Yes, no, no idea. What is the case? Okay. What about this? चलो दो तीन इंस्टीट्यूशन लिखता हूँ मैं. Among these, which of the following can be categorized as state? I'll give you an option. Which of them is a state under Article 12? Tell me. What will be the correct answer here? Yes, please. D. D is in 2 and 3, that is NCRT and SBI. Okay. You know about UIDAI, right? Authority for Aadhaar. Fatima says B, that is 3 and 4. Okay. Adarsh, nahi, Aadhaar, Adarsh card, new card. Okay, quickly. This is not state, this is not state, this is a state, this is a state. This is constituted under the Banking Regulation Act. This is constituted under the UIDAI Act. Hence, both constituted under respective state legislation of Parliament. Hence, a state. So the correct answer is 3 and 4 because 1 and 2 is not state. Let's understand why 1 and 2 are not correct as state. Yeah, Amrutesh, I got that. Okay, let's go through this quickly. Now in this case, Takraj Vasandi versus Union of India, it says the court held that Institute of Constitutional and Parliamentary Studies, a society registered under the Societies Registration Act, is not a state within the meaning of Article 12. Why it is not a state? Because this institute is neither an agency nor an instrumentality of the state. It is a voluntary organization and its object is not related to the government's business. Its functioning, or in the functioning of the society, the government does not have any deep or pervasive control. So basically the control between, in terms of function, finance, management, administration, etc. is missing, and that's why it is not a state. Next, NCRT, Chandra Mohan Khanna versus NCRT. Now this is a very peculiar case. Now it says that following the Tekraj Vasandi previous judgment, Supreme Court held NCRT, that is National Council of Education and Research and Training, is not a state. See this. It is not a state within the meaning of Article 12. It is a society registered under the Societies Registration Act, and the objective of NCRT is to assist and advise Ministry of Education and Social Welfare in implementation of government policies and major programs in the field of education, particularly school education. And these activities are not wholly related to the governmental functions. My question to you is this: do you agree with this judgment? Or do you think this judgment has certain concerns? Yes, no, no idea. Fatma, do you agree with this judgment?
Not properly because NCRT,
It
maybe, but because NCRT is an autonomous body, we have seen a lot of changes in the syllabus and the pattern.
Sure.
The political influence is one more in that.
So see, yes. See, a question could be asked. A question could be asked, although I'm not sure, but a question could be asked with respect to critical analysis of any Supreme Court judgment, and this has been asked in the past. They basically asked to critically analyze the Supreme Court judgment with respect to their decision of declaring NJSE Act as unconstitutional. So critical analysis of Supreme Court judgment is important because it also gives us an understanding how to think in a different manner. So yes, this judgment could be critically analyzed, stating that most of the functions which the NCRT board performs are closely related to the governmental functions, and whatever books it prepares is for the government schools or the public schools, also referred by some other schools as well. But on the contrary, the reason given by the Supreme Court is this, that it is not a state because the object of NCERT is to assist and advise the Ministry of Education and Social Welfare in the implementation of government policies and major programs in the field of education, particularly school education. And these activities are not wholly related to government functions. So the courts have highlighted that the function of NCERT is an autonomous function, is not associated with governmental function. First point. Second, governmental control is confined only to proper utilization of the grant, and in that regard it's an autonomous body, and Article 12 should not be stretched so as to bring every autonomous body which has some nexus with the government within the sweep of expression state. So far this is the judgment. Now tomorrow this judgment could be overruled. We have seen that there are a lot of judgments which can be overruled in the future. So on that point it's also important to understand critically various Supreme Court judgments, particularly those on which there are a lot of certain issues involved. So NCERT definitely works in collaboration with the government, but or yet the Supreme Court have said that this is not a state. So as of now, just remember NCERT is not a state. Same controversy applies with BCCI, that is Board of Control for Cricket in India. Now Amritesh, what do you think? Why is BCCI not a state according to you? The court have declared in this case, Zee Telefilms Limited versus Union of India, courts have declared that this is not state. Fine. But what do you think that why courts would have said that it's not a state under Article 12? So technically you're saying Sachin Tendulkar never played for Team India, it played for Team BCCI, or Virat Kohli never played for Team India. If it is a profit based body, then it's an institution.
So government doesn't decide which player needs to be selected and which not. All the functions are autonomous. I think they are kind of autonomous because BCCI decides both.
Yes, they are not related with the governmental functions, and government has no authority neither with respect to the functioning of the board itself and also with respect to the selection of players. That is a total discretion of the board. Yeah. So this is what the courts have also come up with, but there are again a lot of criticism of this case because ultimately they represent India or Team India, right? They wear a proper jersey of the country. So technically they represent the country. And since they represent the country, how can the government be not associated with that team? Or how can be India not associated with BCCI? So it's a very complex case. So it says Supreme Court applied the test laid down in Pradeep Kumar Viswas to determine whether BCCI is a state according to majority opinion, found that it is not a state because of the following facts. So what did the court say? That board is not created by a law of parliament. First point on which BCCI is not a state is that it is not created by an act of parliament. It is created, in fact, do you know how BCCI is created? It's created, I think, through Society Registration Act in Chennai, in Tamil Nadu. No part of share capital of the board is held by the government. So there is no financial control. There is no financial control. Then practically no financial assistance is given by the government to meet the expense of the board. Board does enjoy a monopoly status in the field of cricket, but such status is not conferred by the state or neither protected by the state. Yes, BCCI has monopoly with respect to the cricket team, but that monopoly is because of itself, not because of state sponsoring by the state. There is no existence of a deep and pervasive state control. All functions of the board are not public functions, neither are they closely related to governmental functions. And the board is not created by transfer of government-owned corporations, and it is an autonomous body. Okay? So it said that BCCI is a private autonomous society registered under Tamil Nadu Societies Registration Act of 1975. But Amritesh, if BCCI according to you is a profit based body, don't you think this hampers the status of the team India? Just a thought. Because if we talk about the Hockey Federation, that is a state. If you talk about Football Federation, that is a state. Legally speaking, they represent, they go to Olympics, right? They win medals. And later, the cricket team, at least for the T20 World Cup, they'll also qualify for they'll also participate in the upcoming Olympics. So how does this work out? Some understanding needs here, or I think there are some gaps in terms of understanding. Okay, moving to a related concept of state with respect to public authority under RTI, Right to Information Act. I'm sure you have heard about RTI Act, right? All of you? Yeah. So again, question with RTI is same, that can you file an RTI, let's say with Suzuki company? Can you file an RTI, let's say with Google? Can you file an RTI, let's say with Apple? And can you file an RTI, let's say with SBI? You understand what I'm trying to highlight here? So we can file an RTI with SBI, but we cannot do so with the rest of these. Why? Because again, these are not public authority under RTI. So what is public authority under RTI? It says public authority means any authority or body or institution of self-government established or constituted. See, almost similar provisions as compared to state under Article 12. So established or constituted by or under the Constitution. So any body, any agency, any institution constituted under the Constitution is a public authority under RTI Act. By any other law made by Parliament, let's say Parliament made SEBI, Securities and Exchange Board of India, Parliament made NHRC, Parliament made Competition Commission of India, so many bodies, or by any other law made by state legislature. Similarly, state legislature also making an institution. Let's say State Electricity Board. Or any other department of the state. Or by notification issued or orders made by appropriate government. Appropriate government here include all types of government. Central, state and local bodies also, or local government also. And includes any body owned, controlled or substantially financed. See, here it has been properly explained. Owned, controlled or substantially financed. And even non-government organizations substantially financed. See this, NGOs which are substantially financed by any appropriate government will be a public authority under RTI Act. Please remember this. Okay. So directly or indirectly by funds provided by the appropriate government. So all of these can be declared as public authority under the RTI Act. And in this particular case, the question was that which is a broader concept? Is state under Article 12 a broader concept, or is public authority under RTI Act is a broader concept? So it says Kerala High Court observed in MP Varghese versus Mahatma Gandhi University, Kerala High Court observed that the definition of public authority has a much wider meaning than of the state under Article 12. And the court observed that the definition of state under Article 12 is primarily in relation to enforcement of fundamental rights through courts, whereas the definition of public authority under RTI is with respect to the entire functioning and seeking information of that public department or that government department. So it says, whereas the RTI Act 2005 is for providing an effective legislative framework for effectuating the right to information as recognized under Article 19 of the Constitution, and thus to fall within the concept of public authority, there must be certain nexus regarding control and finance of public authority over the activity of private body or an institution or an organization. So the concept of public authority according to Kerala High Court is slightly wider as compared to the context of or the concept of state under Article 12. Why? Because RTI is a framework to effectuate the concept of right to information or freedom of speech and expression under Article 19. Okay? So these are some of the important highlights with respect to state and public authority, state with respect to Article 12 and public authority under RTI Act. Any doubts, Amrutesh, Krishna? I hope today's session you learned a lot of things. You understood the requirement of UPSC based on those practice questions. I hope it helped you, right? Okay then, see you tomorrow. Tomorrow let's discuss about right to equality and also right to freedom. Okay. Okay then, thank you. Yeah, bye, good night.